Good morning, everybody. Welcome
Morning.
to our negotiations. First off, I would like to express my thanks and my appreciation for allowing me to take last week off for personal reasons that were beyond my control, and I really do appreciate that. Because of that, we did agree to extend, due to those extenuating circumstances, the date for the initial proposals to be put on the table to today, March 11th, and that's what we intend to do, is to put finish putting all the subjects that we are going to put on the table for today. Before I actually go into our proposals, there's a couple of just little housekeeping matters I would like to go over. We're sending around the sign-in sheet, so before we caucus today, I want to make sure that each party gets the proper the sign-in sheet. The next important thing is setting the next meetings. I wanted to go over those dates with you because I have reserved them with Del Mar College and made sure they were available. And I want to go over them with you because there was one week where we had a couple of options, and I wanted to tell you what we found out yesterday, that only one of those options is going to work for us. So let me go over those dates with you so that we can publicly post them and not have to worry about that and just have it all set and scheduled already. The next date that I have is Wednesday, March 25th, 2015.
Correct.
After that, we have Thursday, March 26th, 2015.
Correct.
We had talked about Wednesday, April 1st, 2015, but that's not going to work for us on Wednesday because there's some sort of workshop that's going to require most of my team to be out, and it would only be me, and I need the help of my team for these negotiations. So we're proposing to move that April 1 to April 3rd, which is a Friday. I think we had discussed that date as a possibility. And what we're looking to do is set 2 sessions from now on until
April 2nd, 3rd.
what I'm looking at is Thursday, April 2nd, and Friday, April 3rd. And I believe that we can be here at least till 6 on Friday. I'm waiting to confirm that with Del Mar.
Okay.
Yeah, because they close at 5 on Fridays.
Yeah, and I don't mind quitting at 5 on Friday. You
I don't
understand?
either, but we didn't realize that was the deal at the last time. So I just wanted to make sure that y'all were aware of that.
Yeah, I've got that Friday open, and that's fine.
Okay, so
We'll
then
do it
for that
Thursday.
week, we'll do Thursday, April 2nd, 2015, and Friday, April 3rd, 2015. The next week I have Wednesday, April 8th, 2015.
Mm-hmm.
And just as, those rooms will be the same. The city's caucus room changes on that day, but that's okay. That's no big deal. But the main conference area and the union's caucus room does not change.
Okay.
And then we had a half day on Thursday, April 9th.
That's correct.
And I requested from 8 to 2 p.m. just because I didn't know what half day we would use. I think that would cover it. So I have 1, 2, 3, 4, 5, 2, 4, 6,
Yeah.
7 sessions set, and then obviously I think we have a week left after that, and we can set those sessions. Y'all can get together and see what dates works for you.
Yeah, on the 9th, I'm going to need to leave a little bit before 2 because I think my flight out of here is at 2:30.
Okay.
So
And
probably
that-
can only work till about 1. I don't mind starting at 8 if that's what others want to do. But
Yeah, and I requested that 8 to 2 p.m. from Del Mar because that allows time for setup, and so they're not kicking us out of certain, because they reserve these for other classes, and I just wanted to be able to allow for that room. So if you want to do, 8 to noon, 8 to 1, 9 to 1, whatever you want to do, just let us know what times that you will be available, and we'll be able to accommodate that.
Okay. And then we extended the bargaining period for a week to accommodate the loss of last week. So I've got that the bargaining period ends April the 17th.
Yes, that's a Friday, correct?
Yeah. So
That's
do you
what I
want
have
to
as well.
do you want to reserve any potential dates for that week at this point, or do you want?
If you don't mind, I didn't know what your availability is because I know that you have the other things that are going on as well. So I wanted to ask some available dates from you so that we can start setting that week as well.
Probably the 16th is definitely available, and then I'll let y'all choose if you'd rather. Right now, I could do either the 15th or the 17th.
Okay.
Why don't we?
We'll keep the Thursday, the 16th for sure.
I'm sorry, what now?
We'll keep the 16th for sure, which is a Thursday. I think we've been trying to negotiate on Thursdays. And then I'll look to see which, I need to see if there's any workshops or anything that would require most of my team, if my team's gonna be missing, I need to figure something out.
It might be good to do it on the 15th and 16th. That way, if we were, making real progress on the
We have an
16th and not
extra
quite
day.
there, we'd have an extra day, so.
I agree. I need to make sure that my team's available, but
That's fine.
that's fine with me. I do.
I'm
agree
gonna
with your-
tentatively put it down, but understanding that you may, I'm just trying to keep other people from getting it.
Right. Okay.
So to clarify, you got set right now is the March 25th, 26th,
Wait,
April.
wait, let me move it. Okay. Okay, go ahead.
March 25th and 26th?
Yes, sir.
April 1st and 3rd?
No, April 2nd and 3rd.
April 3rd.
April 2nd and
It's a
3rd.
Thursday and Friday on that week.
April 8th, half day on the 9th.
April 8th all day and a half day on April 9th. And the half day will be determined by Craig's availability because he has an out-of-town engagement.
And the 15th and 16th are pending.
Yes.
Well, the 16th for sure.
16th for sure.
If they're not available the 15th, we may move that to the 17th.
I'm sure that we, especially since it's the last week, I like the idea of having that extra day.
So, yeah, I've got it for the 15th right now, but you let me know.
Okay. Maybe we should just, if we're available all 3 days, just reserve those 3 days.
If you want to.
Oh, yeah. I think by that time we should have narrowed down a lot of the issues. It's hard to do that at the beginning because there's a lot of background work we have to do, and it sometimes is counterproductive to have negotiation sessions back to back if we're not able to do our homework. But at that point, I think that we would be, it would be okay. Do you know what I'm talking about?
Sure. Yeah, and I mean, if it's turning out not to be productive, we can always, postpone a session or whatever.
Sure.
But, Johnny was pointing out to me that on the April the 2nd, that we may need to start a little bit later that day.
Okay.
We got normally a 9:30 start point, but what about 10:30?
Thinking about that.
Let's just leave it as it is right now. I mean, you can always do caucus work or whatever.
Absolutely.
And I can be doing caucus work while.
Absolutely. We usually we do a lot of work here anyway, so we will do that. If we need to start late, we can definitely accommodate that. And since it's a weekday, I know that they do have night classes, so I have to check to make sure that, number one, the rooms are available, and if they're available, that we could utilize them even later, okay?
Yeah.
So if you wouldn't mind somebody just sending me an email so I could forward it to Del Mar on that, for that date, particular date, what was that, April 2nd?
Well, let's just reserve the room for the entire day.
Right, but I'm talking about.
I mean, if
we
I
needed-
got coffee and donuts, I'm good to go.
Yeah. It's reserved for all day. I just want to make sure that we have it past 5 if we need it.
Oh,
Is what I'm
on
talking
the.
about, on the 6th. If it is, on the 2nd, especially if we start late.
Oh, okay.
Do you know what I'm saying?
Okay, yeah.
I'm going to pass out now our total package of initial proposals.
Does this incorporate the prior proposals you
Yes, it
made, or is
does.
this in addition to?
This incorporates everything. Let me tell you how I did it. All of the stuff that's already on the table is in black. All the new stuff being presented today is in blue. And I will point them out to you. We'll go through them and I'll point out the pages, etc. So what I'm giving to you now incorporates, I guess it basically takes over the last document because it has all the same things we have, all the proposals we're making or changing today are within this document. And we did talk about, now since we have all our initial proposals, Craig and I are going to be working on you know, how to do the counter proposals, and so we're going to be working on organizing that so that it goes more efficiently and more quickly. Here, I have copies for your team.
Are you gonna send these to me electronically?
Yes. There's a couple of slight changes that are not reflected. I'm going to talk about them as we go through them. When I was going through it, there's a couple of mistakes in here that I need to correct, and they will be corrected in the electronic version that I send you.
Okay.
And I'll send it to you immediately as soon as we go through this, so I can make sure that it's accurately reflected in the electronic document that I'm going to send to you.
Okay.
The first new proposal starts on page 9. And there's 2 proposals on page 9. Number 1 is relief. This maintains a status quo on relief with firefighters who are actively engaged in firefighting duties at an emergency scene for more than 3 hours. It states that they'll be relieved from duty, given a rest period, etc. And we did utilize, when I started, I was trying to do what you did and include what the sources were. It's, I believe it's similar to, I can't exactly recall, but it may be almost exactly your proposal on this particular issue.
Okay.
Unfortunately, when I was doing it, I don't think that I continue to do the source, but I will be happy to provide that to you after this. On the reassignment from fire prevention, with the exception of the fire marshal, any firefighter who has been assigned to the fire prevention duties for a period of 5 consecutive years may request reassignment to other duties. Such request will be granted as soon as a vacancy is available. And what we understand that to mean is that such request will be granted once the vacancy comes available, and it's not at the chief's discretion at that point. And I want to make sure that we're all on the same page on that.
Okay.
Okay. The next proposal starts on page 12. The last 2 proposals we talked about were under working conditions. Page 12 is under compensation.
Okay.
And what we have done is we have identified all the proposals that have any kind of economic value with regard to a total that goes towards their compensation is included under this this particular category. Number 1, the wages. On wages, page 12, number 1. Ranks and classifications. The basic ranks and classifications within the fire department shall be established by the city by ordinance pursuant to Texas Local Government Code, Section 143-021, and its management rights. This is merely restating a management right that we currently have, and we will retain. As it is set pursuant to the statute, the city has, in every year during its budget processes, passes an ordinance that establishes the classification and ranks and the numbers associated with those, and that's part of the budgetary process. This actually maintains the status quo from the last contract. On number 2, steps. This was from the last, this reflects the steps from the last contract. We looked at your proposal and we outlined it the same way. On the steps, we identified the steps, but what we did add, we were trying to figure out and outline what the steps actually mean. So between each step, we wanted to see what kind of percentage increase there was between each step. We calculated that, and I had to put approximate because the calculator I was working with did not have enough digits, so I think it rounded up, I think it rounded down sometimes. We can work together on what those actual percentages are and agree to what the numbers basically speak for themselves. It's going to be the same step system that has been in place. We don't intend to change the step system. We just wanted to clarify what it means, okay? So that's why I put approximately, and we can discuss that. On number 3, base wages. Using the step system, this is the first year. It would be commencing on the date this agreement is ratified and executed. And when we're talking about commencing on the date the agreement is executed and ratified and executed, I was talking to how this would go on in payroll and human resources. The way that it's done for general employees is it becomes effective the first pay period after, I guess, the agreement is done. So I wanted to let you know that's what we intended it to be. We may need some clarification on that or some clarifying language if that's what we mean by that. The applicable monthly rates for the current firefighter basic ranks and classifications, and the steps within those will be as follows, which includes a 0.5% raise on the current base wages. And that's what we calculated there. One thing that you will notice that we did add in section 2 steps and number 3, the base wages, is the 120-month step for battalion chief. That was not in the old contract, and we have added that in there. As far as I can tell, the step between 4 and 5, if it's consistent with the current steps on the battalion chief section, it would be approximately a 4.5% raise. Of course, we can pin down those numbers. So the number reflected there, that $73.29 on the base wage for battalion chief, 120 months, should be a reflection of whatever the 30-month step is times whatever the percentage on the step should be. So I believe that number is close, and we can pin that down as well. On 3B, which is base wages, after the ratification and execution of the contract and that 0.5% raise, we are proposing 0.5% raises for the next 3 years after that, essentially making this an almost 4-year contract, which would end September 30th, 2019. And that would be 0.5% raise on each and every step in each category. On supplemental pays, page 13.
So,
Oh, go ahead. I'm
Roxy, let
sorry.
me make sure I understand. So there would be a 0.5% raise on the effective date of the contract.
Yes.
And then commencing at the start of each fiscal year after that, 16, 17, 18, another 0.5% raise. And so I guess we'll get to duration at somewhere down the road, but that basically you're looking at a 4-year contract.
Right.
That would end,
yeah,
that would
and-
end, I guess, September 30th, 2019?
Yes.
Okay.
That's what we're looking at. And if this is what we're proposing, we're at the
I
initial
understand.
stages, so
Sure,
that's where
sure.
we're starting off from. On supplemental pays, the certification pay, I believe, at this point, we're proposing status quo. We are currently costing out the proposals that you have given us, so we will, I'm sure we're gonna delve further into those. On assignment pay, we looked at your proposal, and we mirrored it with but with ambulance duty being $25 per shift. I think you added that, or we added that, but that's the difference in there. I think what you did in your proposal was consolidate, the people who served on the ambulance between 0 and 5 years, 5 to 10. I think you did away with that and consolidated it into an ambulance duty pay, if I understood that correctly.
Mhm.
And so what we did was we liked that idea on the ambulance duty, but we did it as a per shift for $25.
Okay. So the way assignment pay under your proposal, the way assignment pay works for ambulance duty is that's $25 per shift actually worked on the ambulance.
Yes, that is what we're talking about.
So if you work 5 shifts in a month, you'd get that $25 5 times. If you work 10 shifts in a month, you'd get 25 times 10.
Yes, that's how we intend that to work.
Okay.
And I just want to clarify, because I was trying to understand it myself on the hazmat or the rescue truck station. Those are that's status quo, and as I understand what's the way it's being done is that you only get you either get one or the other. You can't get both, if I understand correctly. And then you get these only if you're permanently assigned to either a hazmat or a rescue truck station duty. And I just want to make sure we're on the same page with that.
Okay,
So
so
you
say
may need to
that.
ask your team.
So you're saying that on the hazmat and the rescue truck, you would get one or the other, but not both?
Right, and then on top of that, you only get this assignment pay if you're permanently assigned. Say if you had to cover somebody who was sick and cover that duty, I don't know that you get that assignment pay. And if that's the case and we need to clarify it, then we need to come up with language to make it clear. Craig, can we go back to, I may have made a mistake on the dates on the effectiveness of the base wages on page 13.
Mhm.
On I think I'm a year ahead on the, when I'm saying that the 5% goes in effect on the ratification of this contract.
Mhm.
And the next dates, I think that first date would be, instead of 2016, it might be 2015, depending on when we.
We're looking at page 13,
Page
item
13,
3B.
Uh-huh.
So we're saying it's a 3-year contract?
No, we're looking at 4 years. I may have gotten those. Our intention is to get it's almost a 4-year contract, including this year. So that's what our
I see what you're
intention.
saying.
That's what our intention is, and I may have miscalculated that because October 1st, 15 hasn't passed, and I was.
So that should probably be,
It should probably be 2015, 2016, and 2017,
And ending on 8.
ending on September 30th, 2018. That's what happens when you have a lawyer doing math.
tell me about it.
So I'm gonna change that on the electronic document,
Okay.
but in essence, our intention is for it to be 4 years capturing this year. Okay, does that make sense?
Right. 4 years starting with October 1st of 2014.
Yes. Okay, so I'm gonna change that. So then that would make the duration ending on September 30, 2018, and I would probably have to make that change as well. It may wind up back at 19, we'll see. So, we'll get there when we get there. Okay. So then let's go back to page 14, that's where we were. Okay, with certification, we went through that. Assignment pay, we talked about the ambulance duty, $25 per shift worked.
Mm-hmm.
Staff assignments is status quo. It should be status quo, that's what we intended. Temporary duties is the same as is being done now. But I did rename, I know you titled it, I can't remember what you titled it, but what I basically did was went to the statute to see how chapter 143 identifies that. It identifies it as temporary duties and higher classification pay. I kind of did that just to be in line with the statute, so we both know what we're talking about. We can definitely talk about what we want to name it, but
No, higher class, I'm comfortable with higher class pay.
Okay, so temporary duties with higher class, and that's basically the particular statute we're working with, and this is, aside from simplifying language and using different name for it, it's basically status quo, there's nothing changed there. On page 15, letter D under supplemental pays.
Education.
The
incentive pay.
education incentive pay, we're going with the, what we had placed on the table previously. There's a mistake in there and I've corrected it. The master's degree should read $250 per month. I believe you're the ones that proposed $300. We're proposing the $250 per month. That's reflected in the electronic document. We're still costing this out. Yours had a, I have a pen if you need.
Here you go.
All that money you're getting in theory,
Yeah.
can't afford a pen.
Your proposal had a grandfather clause in there. We don't have that in our proposal, and we're still analyzing that and figuring out the costs associated to that. Longevity pay is status quo. And that is $6 per month for each complete year of service up to a maximum of 15 years of service. And then from 15 to 25 years, it would be $4 per month with a cap at 25 years of service. Overtime on the bottom, this has changed somewhat. The fire department civil service personnel shall be paid at an overtime rate when applicable in accordance with the minimum requirements for such pay imposed by applicable state and or federal law. This next sentence, most of it was already in the old contract, but under a different section. It wasn't under overtime. For purposes of overtime calculations under the Fair Labor Standards Act, the city shall utilize a 27-day work cycle. Sick leave, vacation leave, personal leave, Kelly days, and trades will not be considered as time actually worked for said overtime calculations. Now that last sentence appeared in the old contract, but we did add personal leave and trades. Because what we're looking at is we want people under the Fair Labor Standards Act, whether it be general employees, firefighters, etc., are entitled to overtime for over the time they've actually worked.
Do they currently pay overtime if people do trades?
Yes.
They pay it to whoever that's on.
Yeah.
Okay.
On page 16, holiday pay, that maintains, we utilized your simplification of your language, but it's intended to maintain the status quo. We included the calculations under section 2 for pay for holiday work that way it's under the section itself and we don't have to be going to an appendix. So we're trying to simplify that as well, but everything
Okay.
is intended to maintain status quo. If there's a mistake in the formula, that the intention is to keep it the same. And on page 17, it's the same thing with the vacation leave. The intention is to maintain the status quo of the old contract. On section A, accrual of vacation leave, when it lists those years, those bullet points, it says 0 to 14 years, 15 to 29, 30 or more years. We made sure to add continuous service because it was in the old contract. For some reason, it was included on a couple of bullet points and not all of them. We just wanted to make it consistent, and this has always been how they do it. With it has to be continuous service. One of the things added to
A firefighter really has to have continuous service without gaps, don't they? I mean, if you leave with limited exceptions, you can't come back in except going through the civil service entry process.
yes, but in terms of getting vacation leave, if they came for 5 years and went out of town for 10 and then came back for another 5 years, they're going to have to start over rather than 10, accumulate the 10. And I think that's the way it works across the board for the entire city.
Okay.
That last paragraph in section A, I think this is new. Use of vacation days shall be subject to the discretion of the fire chief, the operating needs of the department, and the request of the employee. I think we added discretion of the fire chief. And of course, that would be reasonable discretion. And of course, he would take into account the operating needs of the department and the request of the employees.
I'm just trying to remember off the top of my head, is there a cap right now on the number of hours of vacation leave that a firefighter can accrue? That's a problem, because if you're capped and the chief says, well, I can't afford to let you go, a firefighter shouldn't be penalized by losing their.
Okay, we'll take that into consideration.
Okay, that makes sense.
And the intention is not to punish a firefighter and say, no, you can't take vacation and then have them lose it. That's not the intention at all. the intention is just to make sure that we have enough people to efficiently run the fire operations is the concern here. So if there's a cap and that becomes an issue, we can probably make a
Okay.
clarification or something like that. On vacation leave B, use of vacation leave for death not in the immediate family. This allows a firefighter to use vacation for such, and we also added subject to the chief's approval for the same concern, for the same reasons that it was added to the Section 8. And that is for, to ensure that we have enough people for the efficient and sufficient operations of the department. It would basically be for the operating needs of the department and the request of the employee, especially if we have a large number of employees requesting all at the same time for this particular deal. On drag up and the rate for the drag up, that's also status quo. We included the formulas in there, so it's under the section itself. On page 18, section E, vacation leave buyback program, that remains the same. I think we took a lot of the language that you had proposed and you utilize it within our proposal.
You're talking about subsection E, vacation leave buyback program?
Yes.
Right here? Oh, I see you. Okay. Okay. Did you mean, you changed the definition of immediate family from the current contract? Did y'all mean to do that?
Oh, did we? Let me see.
In the current
What
contract.
page is that on the current contract?
Page 12,
Let me get that.
immediate family includes some people that are not immediate family.
Let's see. We have
Like mother-in-law,
parents,
father-in-law.
step-parents, legal. We have legal guardian.
Wait, no, it says-
Spouse, mother-in-law,
Mhm.
father-in-law, children, brothers,
Immediate
sisters,
family.
grandparents, and grandchildren. No, when I'm looking at it, it says the same thing.
So the purpose is to maintain the status quo?
Yes, that's the intent. We didn't take anybody out of there. And it should reflect what the definition of,
Okay. And so 18, vacation leave buyback program, that's status quo, or did I miss something?
no, that's status quo. I think it's just simplified language. The intention is to leave it the same. Sick leave on page 18, section 1, accrual of sick leave is the same, the intention is to maintain status quo. I believe we used a lot of your simplification on that.
Good.
Section 2, use of sick leave in the event of death or serious illness in the immediate family. Immediate family here should be the same as identified in the section we're looking at in the old contract right now. But what we added was that use of these sick days shall be subject to the discretion of the chief, the operating needs of the department, and the request of the employees. And this opens it up for discussion because serious illness is defined by law, and we can look at that and talk about what we both understand that to be. What we don't want to happen is, somebody has a paper cut or has a cold and someone's utilizing that as a serious illness, and it affects the operations of the department. Our intent is to be reasonable, and to allow for such things for when there is death or serious illness, but we're also trying to make sure that everybody is accountable for it as well, okay?
Okay.
If there is an FMLA issue, that really you know, our intention is not to forego the law. If it's an FMLA issue, of course, that we're required to allow that, so we can make a clarification on that if necessary. But we do understand that, you know, we have to take FMLA into consideration as well. So our intention is not to override that or anything. It's not mentioned in there, but that was something that we were thinking about, and we should probably discuss and possibly clarify.
Yeah.
Because our intention is not for somebody to be on FMLA and the chief says, no, you can't take sick leave. That's not the intention. Section 3, sick leave retirement pool, and the drag up for, and section 4 drag up for unused sick leave should be status quo as well. On page 20, section 5, we maintain status quo, but we included the formulas under that section so that we don't have to be going back to exhibits. Page 20, personal leave, that should be status quo as well. On all these sections that I'm talking about on 19 and 20, we've utilized simpler language. We looked at yours and we incorporated that into our proposals. Okay, and then page 21 is the health insurance plan.
So personal leave
Oh,
is
sorry.
status quo?
Yes. We don't intend to change the way it's accrued and the way it's used.
Okay.
And we did utilize some of your language in our proposal. On page 21, we start with the healthcare insurance plan, and it goes from page 21 through page 29. And I bring that up because it looks, what I did was I did a red line of what we're doing here. It looks like we deleted a lot, but in essence what's happening is that we had a lot of the actual, you know, with the healthcare plan, the actual plan document is what governs, not this, we contract for the healthcare plan through the collective bargaining agreement, but what actually governs your healthcare is the healthcare plan. Unfortunately, a lot of things that are included in the healthcare plan were included in the collective bargaining agreement, and we believe the proper place for that is the governing plan document. So I went through with the benefits manager, and what we did was basically delete everything that's already reflected in the plan document. If there's something that you have an issue with, we'd be happy to discuss it. Our intention is not to change the plan document as that governs, but our intention was to simplify what needs to be included in the collective bargaining agreement and what needs to, and what is governed by the actual plan document. For instance, we deleted the listing of the premiums because it is clear that the formula for the premiums is that the city pays 100% of the employees' premiums and 50% of the premiums for dependent coverage towards the city care fire health insurance plan. That's the key issue as to how we pay premiums. Listing these premiums out, we want to take that out because, as you know, there's premium plan changes, but no matter what happens to those premiums, the city's still going to cover 100% of the employees' premiums and 50% of the dependents. So that's the reason that we're trying to simplify and delete this. All the red lines that you find.
So what you've got printed on pages 21 through 29 are the stuff that's actually in the contract presently that you're either eliminating or.
Right.
What's in blue is what's in the contract now that you're keeping.
Right.
What's in red
Is what we what we're eliminating.
Lost out
We
is-
did, right, and we did some additions, but they're at the end on 28 and 29. I haven't gotten there. But what I'm saying is that we're not eliminating anything, like we're not eliminating benefits. What we're doing is eliminating language that already appears in the governing plan document. Because if the language came in here and it was in conflict with the plan document is what governs. The things that we're leaving in here establishes, yes, we pay your 100% of your premiums and 50% of the dependents' premiums for your city care fire. We also include the calculate of how we calculate premiums, because that's not in the plan document. We also left in, our rights to do requests for proposals and renegotiate healthcare plans, etc. We included the coverage of the OPEB and GASB liability. and things like that. The intention is not to change the health, with these red lines, not to change the healthcare fund, but just to simplify the contract and have the plan document speak for itself the way it needs to, and the collective bargaining agreement speak to the things the plan document does not speak to.
Okay, so I just want to make sure I understand. Your health insurance proposal, if I summed it up, we're maintaining status quo.
Yes.
But some of the verbiage that's in the contract is going to be eliminated because it's in the plan document.
Yes, but there's a couple of additions at the end that will qualify that here in a second, but our intention is not to take away the city care fire benefits or plan by deleting what's in the plan document already. We're just trying to simplify the contract on that end.
Okay.
Okay, and we have two additions to the section of the collective bargaining agreement under the healthcare plan, and they're all related to issues that we face and we may face with the Affordable Health Care Act that has been passed by the federal government. On page 21, you see that we added a section D called Compliance with Federal and State Laws. Says the city has the authority to make plan changes to remain in compliance with federal and state laws, including but not limited to the Affordable Care Act, in order to avoid penalties and excise taxes, to satisfy the statutory and legal coverage and benefit requirements, and to preserve the flexibility.
Where are we looking on page 21?
28.
Oh, 28.
I'm sorry, page 28.
I couldn't find it.
I apologize. I'll start again.
The section marked compliance with federal and state laws?
Yes, sir. And that says, the city has the authority to make plan changes to remain in compliance with federal and state laws, including but not limited to the Affordable Care Act, in order to avoid penalties and excise taxes, to satisfy the statutory and legal coverage and benefit requirements, and to preserve the flexibility to make needed changes to comply with the federal and state laws, including but not limited to the Affordable Care Act's complex and evolving requirements.
Okay, let me just read that to myself a second. The only part that's kind of throwing me is this part that says, and to preserve the flexibility to make needed changes. I mean, what does that mean?
Well, it's not talking about the premiums at this, that are set. We have on, this is what I'm talking about. On page 22 in the middle, we have a sentence in here that has in the previous agreement, and it's, and I'm including the red line paragraphs, 1, 2, 3, 4, 5, 6. It's the 7th paragraph down.
Plan changes mandated by federal health care legislation.
Will be implemented as required. And that's kind of the flexibility that we're talking about. We're not talking about we can't go rogue. What we're talking about is the flexibility that we need in order to satisfy any statutory requirements on any, whether it be the Affordable Health Care Act or whether it's amended in some way or a new one comes up.
Yeah. What does this new paragraph add that the paragraph on page 22 you just pointed out to me didn't allow you to do?
The paragraph on page 22 does not address any potential penalties or taxes.
Okay, but that I'm getting back to that word flexibility. I mean, is this required to comply with federal law? No, but it allows us the flexibility we need in case we need to comply with the federal law. You're not talking about that kind of change.
Say that again.
You saying, well, we're making this change. Well, why? Are you making the change to comply with a new federal law? No, it just gives us the flexibility we need.
No, that's not what we're looking for. I mean, we have flexibility with regard to, that's already integrated into the contract with the ability to renegotiate the plan document, et cetera. But no, the flexibility is not so that we'll sit back and say, I think I'm going to change the fire just because, it may, we're looking at the flexibility that we need in order to comply with a requirement that's imposed on the city. And we can work on that language, you
Okay,
know, that's the
yeah.
intent. I understand what
Okay.
you're saying, and we can, if
Okay.
you have some a proposal that will, narrow it in some way, but what we're talking about is just any, the flexibility needed just to, if they come up, you never know, the federal government can have a new healthcare act that's been in the process for a couple of years, and then they pass it today, and we have to be in compliance by October 1st of 2015. We really need flexibility in order to get that change. If there's a major change that we need to do in order to avoid some tax or penalty, etc. We really need that flexibility within that small amount of time in order to accomplish that. And that's really kind of an example of what we're looking at when we're talking about flexibility.
Okay.
On page 28, there's an additional provision, and this is specifically regarding a potential Cadillac tax.
Can I back up a minute on page 28? Item number 2 there, you've eliminated, the city's not wanting to make payments anymore to the Corpus Christi Firefighters Health and Benefit Trust.
Let me talk about those eliminations right there. Those eliminations right there, I don't believe they were proper under the healthcare plan. I think because the Health and Benefit Trust is kind of separate in of itself, and the
So that's gonna appear
basic
someplace
li-
else?
Well, from our proposal, you have placed that contribution to the Health and Benefit Trust as a proposal on the table.
Right.
We're considering that for a counter, and we didn't include it in our initial, because we're looking at
Okay.
what your initial proposal is.
Okey doke.
But we are considering it. That basic life insurance coverage for each firefighter equal to the firefighter's annual salary appears on page 29 under a separate section in of itself. That's intended to maintain status quo.
Okay.
And also, we did a separate section for the supplemental insurance also. City shall provide basic life insurance coverage for each firefighter equal to the firefighter's annual salary. I was just trying to organize, because that really doesn't fit under
I
the
got
actual
you.
healthcare plan.
I got you. Now, so come back to the Cadillac tax. Is
Yes.
it your understanding that your plan is gonna be a Cadillac plan under current
We don't
law?
know. That's the issue. Let me read section E, I'll preface it with this. On this Affordable Health Care Act, it's really difficult to understand with its ever-changing thresholds, whether it's something that we would even be subject to. I am not gonna even try to say that I even semi-understand it, I don't know that a lot of people do. But there is a potential that at some point, the threshold may change, that may make us liable for some sort of, for a Cadillac tax or some sort of penalty. We don't know. At this point, when we're looking at it, the answer, Craig, is most likely not. But I'm just saying that I'm not an actuary, I'm not an insurance specialist, benefit specialist, I don't know a lot about it. But most likely not. I really don't know that it's something that we will actually have to deal with. But it is a possibility, it is a potential liability. It's a potential unfunded liability that we would like to avoid, or at least kind of address, or have a backup plan in order to address it. And this is our initial proposal to start, Craig, and this is our initial proposal to start
I
that
got you.
discussion, okay?
Okay.
So what we're proposing is here's the base, this is what we need to deal with, at least have a safety net for both of us, and let's talk about it and see what we can come up with.
Well, I'm
And-
thinking that the Cadillac tax doesn't become an issue until 2018 under the ACA as it's currently. And if that's so, maybe an option is if it turns out at that time, I'm just thinking out off the
Sure.
top of my head, at that time that there's a Cadillac tax problem, that we would reopen the contract to negotiate how to deal with that.
Okay.
Something like that.
Well,
Because that's pretty far down the road. That's 3 years away.
that is, you're right. And that is a potential, the only concern that I thought about that. The only concern I have with it dealing at the 11th hour is I don't know when they will start the calculation and assessing that tax. I don't know if the tax will be due in 18 based on 2017 coverage. And that's why we're we threw out that date of April 1, 2017. And basically what this is saying, and this is this is what we're starting off with. We want to address how are we going to handle this. And right
Okay.
now, since the city has to have, all their liabilities funded, that is an unfunded liability at this time. And what we're proposing is that if at some point we become liable for a Cadillac tax or whatever it becomes, because this Affordable Care Health that is changing every day, whatever it becomes, that the union and the firefighters would cover that tax. And if they couldn't, then we would transition into the regular city care that every other general
So y'all
employee
have
gets.
two healthcare plans, a sort of a basic plan and a higher plan, and I take it most of the Corpus firefighters are on the higher plan.
Oh,
Well, no, let me actually clarify that. We actually have, there's 4 plans. There's a city care fire, city care police,
Public safety.
public safety.
or public safety, excuse me. There's a city care
Premium.
general and a city care premium. Most general employees are in the city care general, is basically what it is. Firefighters, of course, are on the city care fire, and the police are on the public safety plan. Most general employees are on the regular city care. And the premium is available to all general employees, it just comes at a higher premium.
For
But,
them?
yeah, but the benefits are actually not much different.
Okay.
There's a very short gap in it actually is, most people choose, when you do the numbers, the regular city care general plan.
Okay.
And the city also if we were to transition, the city would offer it at the same level and cost to the firefighter. If the transition had to occur, then they would offer it at the same level and cost is to all other city employees. And of course, the city contributes I don't have the numbers, I can get them, but a percentage to the employee premiums and a percentage to the dependent premiums as well.
Okay.
It just wouldn't be at 100%. So that's what that is. Those are the 2 additions to that part of the healthcare plan that we can discuss. I already went through the supplemental insurance and the life insurance.
Mm-hmm.
On page 30, where we have proposed the impasse procedure. In doing this impasse procedure, we did, and what I can do is I can send you a highlight of some changes on it, but I used your impasse procedure proposal as the basis for this. I really liked where it
Okay.
was going with the funneling process.
Mm-hmm.
There's a couple of additions I did. Basically, I added that the negotiations would start in accordance with the Chapter 174, which is the Fire and Police Employee Relations Act, just so it's clear. At the dispute conference, an impasse can only occur on proposals that were made on mandatory subjects of bargaining. So therefore, like an impasse can be it just clarifies that an impasse can only occur on a mandatory subject of bargaining, and those will be what are included in that disputed issues list. I did add in there that only upon mutual agreement of both parties can a permissive subject be included. So if there's a subject that's not mandatory, but we're bargaining on, we both agree it needs to be in the contract, and we want for it to go through to mediation, we can include that in there. It leaves that option out. I think it also helps the negotiations become more meaningful, and that there's more discussion and negotiations on permissive subjects, and we can probably that would help get resolution to that before we can get to an impasse, and hopefully maybe avoid an impasse. On C, the no issues allowed, you had put in your proposal, neither party is allowed at the dispute conference to add any new issues. I added or throughout the rest of the impasse procedure. We don't want someone, we need the issues identifiable at the very beginning, and it needs to remain consistent throughout the rest. On section 2, with regard to the optional mediation, I added that the function and powers of the mediator shall be specified as it is in section 174.151, and that's the mediation jurisdiction given under the statute. And that's open for discussion because there's a lot of different factors here. In Corpus Christi is unique, and we may need to throw out things and say, well, maybe this is something we should include, or this is something we should give the mediator authority to do. So that's open for discussion. Section 3 on fact-finding. The big difference here on fact-finding is, number 1, only mandatory subjects can go to fact-finding, which forces us to really negotiate during the dispute conference and the mediation on permissive subjects. But mandatory subjects go to fact-finding, and the fact-finding is not by one fact-finder, it's by a fact-finding board. And that would be a board made up of 3 fact-finders, 1 picked by the union, 1 picked by the city, and a neutral picked by those 2 fact-finders.
Okay.
And it's basically the same. There'll be a hearing and transcript, etc. It's advisory only. And one of the things here, also, another big change is that I'm proposing a package proposal to the fact finder rather than an issue by issue dispute, or an issue by issue deal. I think the issue by issue would be better served in the mediation and or the dispute conference and the mediation, and it kind of forces the funnel a little bit tighter to narrow down the issues before fact finding, and then even narrower if we have to go to a binding arbitration.
Yeah, and I'm not pushing back. I understand this is your
Yeah.
proposal, but it actually defeats that purpose. And the reason that I think that it defeats that purpose is the whole purpose of fact-finding is to get feedback from the fact-finder or the fact-finding panel about the reasonableness of your positions on various issues. And so if the fact-finders only pick one proposal or the other, then that's not going to, the whole idea is the fact-finders say, okay, we agree with the city on 5 and we agree with the union on 5. Then that makes us look at the ones we lost and say, okay, we really need to try and refocus, and that was my thinking.
Okay,
But you don't get that feedback from fact finding if they just pick one or the other. I mean, it may have been a 51-49 vote, and so one party's encouraged not to give an inch, and the other party's encouraged to move their ball a little bit, and now it may flip it. But we didn't get that feedback, so we didn't resolve any issues.
That's a good point. And let me tell you what I was thinking, the basis behind, and this is, obviously, we can discuss this more and tighten it up, and I think we can find a resolution to this. But my thinking with coming from that part was that on fact-finding, we already went issue by issue on the dispute, and then hopefully the mediation, and hopefully we get a lot of that taken care of. And by the time we get to the fact-finding, we ask the fact finder to not split the baby, to pick one issue or the other. But in fact, if you have several issues, they can essentially kind of split the baby and say, okay, I'm going to give the union 3 and the city 3, and where do we really get from there? So that was my concern. We really need an effective impasse procedure, and I'm trying to figure out a way to make it the most effective and to narrow that funnel down.
Okay.
So if you can come up with an idea, now that you know my concern and I do understand your concern, in your next proposal, let's see where we can fix that. But that's where the thinking is, and that's what I'm trying to get to. With the fact finding advisory opinion or decision, we left that in when we come back and have the party meeting. There's some timelines in here. I think I extended a couple of them because it's not one fact finder, it's our fact finder board, and it's kind of harder to get 3 people together, etc.
Mm-hmm.
But the other significant change here is that once we have that meeting on the fact finding meeting and we pursue arbitration, and as I read it, as I understand it, fact finding and arbitration are going to be mandatory. Is that correct?
Yeah.
Okay, they're going to be mandatory. That once we get to the fact, and this was with the package proposal at fact finding proposal. When we get to binding arbitration, we're going to have to modify that proposal, reconfigure it based on the fact finder's recommendations, any resolution that happened at that post fact finding meeting, and then represent it to another panel of arbitrators, and we're proposing another panel of arbitrators, which would be pick the same. It would be one by the union, one by the city, and a neutral. And I think that would just give the most fair and equitable hearing to everybody. It would be based on, we want to ensure that the fact finding and the arbitration are based on facts and the evidence presented, and et cetera. And I think if we have a board, we can ensure that, that we picked one, you picked one, and there's a neutral pick by them. But we would have to have a whole other hearing in order, on those issues, and the idea is that by the time it gets to arbitration, if it does, that the issues would be very narrow, and it'd probably be one or two issues. And the only thing that can go to arbitration is a mandatory item.
Okay, and at binding arbitration stage, is it one arbitrator or is it three again?
3 again.
Okay.
We're proposing a fact-finding board and then a fact-finding arbitration. And like I said, the goal in our proposal is how do we make this the most effective, and once we kind of start pinning down things that we agree on and things that we don't, we can come up with a chart to identify a timeline, because that will help us figure out, how can we deal with the duration clause. And
Okay.
so I know that's going to be very important. One thing that I was thinking about when we were working on this impasse procedure, Craig, is that we have I think it's actually a benefit that our fiscal year ends a little bit later than it used to, which is September 30th.
Mm-hmm.
And, previous times it's always been, since I've been here, the union usually makes a request either in December or January to do the collective bargaining. I don't see why we shouldn't start doing that and start doing it earlier and try to get it done during the same timeline way before October 1st. I think that we should continue that, and having that in mind is, I had that in mind when I'm working with this impasse procedure and the duration provision that we're going to propose. Okay. So read through the impasse procedure, but those are kind of the major differences in our proposals. I'm really encouraged by this impasse procedure because what we're looking for is a way to guarantee that we end into contracts in a timely manner.
Right. Okay.
And then the next, let's see.
Page 46, conflict with civil service.
Yeah, that's just, it was the same in the last contract, and we just wanted to make sure that it clarifies that this collective bargaining agreement will govern over, any civil service statutes that we're allowed to amend or.
Yeah, and I don't have a problem with that provision. I mean, I think it's a requirement of the law, whether we
Right.
have it in the contract or not, but
Right.
if it makes everybody feel better to have it in the contract.
Okay.
Okay.
And then the last, I have a concluding provision in there, but that's just kind of a form that we use.
Yeah, and you've got the duration to 2019.
Yeah, that should be 18.
That's what I thought.
And I think I've changed that, and I'm gonna send you, I waited to send you the electronic version because of things like this, so that I can send you everything with the correction.
Okay.
And then, and we're just saying it ends on that date. Given in mind what I talked to you about earlier, that we bargain early in the year, start bargaining as soon as possible during that year, so that we can have time and get it all done, and have an impasse procedure that works before the end of that date.
I know y'all are working on maybe some counters today, and we're working on some counters to the grievance procedure and discipline that you proposed earlier, and we may have those for you in a little while. But just a couple of questions about this, and then I want to study it, and then I'll probably come back and ask you some more questions.
Sure.
But in terms of the overtime provision, you're proposing to do the minimum required by the FLSA, and I think, as we both know, you currently do more than that. And my question's going to be, and this is for your fiscal people, how much money do you think you will save per year doing that? And the reason that I'm asking is, to the firefighters, it's going to be a whole fiscal package. I mean, if I'm going to lose, you know, once we have an annual figure, we're gonna save $1 million a year, then I can divide that by the number of firefighters, and I'll know what kind of pay cut they're taking on average, and then I can compare that to the wage increases and the other increases that are proposed and see on balance,
Okay.
do we, at the end of the day, do we lose money or do we make money on the deal? So,
Okay. I understand what you're saying. I think, you know, I'm working on trying to, I think it's a little hard to come to that calculation, but we're working on making sure we get something that's kind of,
It'll be helpful
You know,
to both of us, because if it turns
absolutely.
out you don't save too much money on it, then, you know,
yeah.
I mean, you're creating a disincentive, people wanting to work overtime.
I think-
Obviously, you always have the ability to order them, but.
Right. Well, and this is the case, Craig. We're not trying to keep people from wanting to work overtime. What we're trying to do is keep people, like if you get paid for a trade and you didn't work that day, but you come back and you get overtime, that's something that, you know, general employees aren't entitled to. You're not
No,
entitled
the
to.
trade I get. It's
So
the
it's-
different formula that you're using to calculate overtime pay
Yeah.
that's the concern.
So we need to talk about it. You're right. I'm actually working on getting that data. It's not something I could get to you in the afternoon or tomorrow, but we have been working on it because it's, even though it seems like a very simple issue, it is not. It's very complex, especially with all the formulas and the 7K exemption that we have to deal with. And
As we went through it, it's the most radical change I saw in your
Yeah.
proposal, by far.
okay.
So,
And we're working through that, and like for instance, we're talking about those overtime calculations. We did come up with 54 after
oh, really?
figuring it out. What we did is, yeah, and we can talk about that later when we start
Okay.
getting into the details. But we did some research, and we finally came with 54, and we figured out where that came from.
Okay.
So, because I kept coming up with 52 also, but like I said, that's what happens when you get lawyers doing math.
Yeah, I got you. Okay, well, why don't we caucus then, and just ask that.
Were you able to come up with, we asked you about the fire pension and insurance, the police pension and insurance, and the city employee, were you able to get that information?
Yeah, and actually, I apologize, that was one of the housekeeping matters I meant to address. I do, that information has been forwarded to me. Unfortunately, I was out, so I plan to get that together and hopefully present it to you at the caucus later today, or if for some reason we don't meet, I will email it to you today.
Okay.
So we do have that information, okay?
Okay, sounds good.
And we'll get it. Okay, I think, are these off an hour?
Yes, they're off
Because,
an
yeah,
hour.
this is off an hour, so it's actually 11:15. So, if you don't mind, we're gonna include lunch in our caucus,
Okay.
so
So, shoot to get back together, what, about 1:30 or something, or?
that sounds good.
Okay.
Okay.
Roxy, what I'd like to do is explain these proposals that I just sent you. I'm sorry I don't have copies for your team, but maybe if you, I know a lot of your folks have computers, if you could forward that
Let
email.
me- Yeah, if you
to
give me a
them.
moment to forward at least so they can try to pull that up.
Yeah.
No.
No.
There it goes.
Is it big enough to share?
Wasn't it supposed to be warmer today?
Yes.
I mean,
You have to go outside to warm up.
you know, but the
Cold
thing
out there,
is, it's
too.
cold out there too.
Yeah.
I mean, in Austin, I know they said the high today was supposed to be close to 70, so.
Put your arm to the other side.
It was supposed to be in the mid-70s here.
So something's going on.
Okay, I have forwarded it, let me,
The other day when it was 80 degrees, it
oh,
was
there it goes,
74.
I got it. Did you get it? Yep.
It's 50 degrees outside, it's 60.
I forwarded the proposals to you. Richie, did you get it? Richie?
So, yes.
Okay, I forwarded, they've, think most people have received it on my side, so I'll give them a moment to open it up and we can start talking about them. And these are counters to the 226, right?
Yes.
Okay.
Counters to what y'all proposed on 226.
Which one do you want to take first, the grievance, Article
Yeah,
24?
just might as well. You know, these were kind of easy to respond to because your proposals had more or less talked about all the same topics
Mhm.
as were in these articles. So, but let me just say before we turn to the specifics of Article 24, I had also at the last session on February 26th, I gave you a preamble proposal that largely tracked your preamble.
Okay.
And I previously have given you an Article 3 recognition that's like sort of a no-brainer, kind of just, you know, rote recognition clause. So depending on how quickly y'all can feel comfortable doing this, I almost think we could TA on all 4 of these, but I know you're gonna wanna go over these 2 that have the changes in them
Okay.
with a fine-tooth comb, but I'd ask you to look at those 2 too. I mean, I'm always about making elemental progress, and the more things we can get out of the way, the better it will be. And I don't think the preamble and the recognition are controversial. I'll look through my status sheet, see if there's something else, but it occurs to me that, and we're so close, I think now in grievance procedure and disciplinary actions that maybe we can TA on those 2. But let's go through this. What you're going to see here, the black is from my original proposal, and the blue and the red are things that I've stricken from that, and almost all the blue and red is in response to your proposal, okay?
Mine's coming up red, so as we go through it, just...
If it's underlined, it's an addition. If it's crossed through, it's a deletion. On mine, it's blue and red.
Oh, okay.
But unfortunately, sometimes with Dell's or non-Apple products, it doesn't.
Okay.
That's Apple's devious way of making you all want to buy an Apple, which, by the way, I recommend.
I have one.
The exclusions, that language is, in your proposal too, that what's in black. I added the blue to make it clear that if it's a statutory claim, or legal claim, like you said last time, it belongs in court. It doesn't belong in the grievance procedure. The grievance procedure is to resolve contracts or disputes about the contract itself.
That's right.
Okay?
Okay.
So I don't think that'll be. In item 2A, in terms of the contents of the grievance, you had added a provision in there that said if your claim is based on an MOU that's been included in the contract, we want you to provide us a copy with the grievance. I did not put that in our proposal, but as we get down the proposal, you'll see that there are discovery provisions that would allow you to require us to identify every document we're going to use at a hearing, every witness we're going to call. So it just seemed like, it wasn't necessary, but, if you want to go back to that, we'll be glad to look at it.
Okay.
I did leave in the concept of, a class action grievance. If it's, if it's a pay claim, hey, you're not calculating overtime in accordance with the contract and it affects everybody. I think the union ought to be able to file a class action grievance without having every single individual sign it. That's just, making it cumbersome. So I did leave that in about the class action, but I put a provision in at the end of A2 at the bottom. If the city feels like we've designated a grievance as a class grievance inappropriately, you can throw that issue to the arbitrator to resolve.
Okay.
Okay? Then the steps I've left more or less unchanged. I think it pretty much is like, the grievance procedure currently works. But where I have made a big change, well, let's just go through them. If you look at the top of page 4, and this is in response to your thing, although I think that's the way it is whether we have it in here or not. At y'all's request, I've added a provision, the grievant, whoever the grievant is, bears the burden of proof by preponderance. Then these other provisions on page 4 in blue are all discovery type provisions added in response to your proposal.
Yeah, because that was brand new. The discovery procedure is kind of something I think that we needed to integrate into this process.
Yeah, so if you look, 2 weeks before the hearing date, you can request, I mean, it's not, on the request of either party, the parties will exchange the names of witnesses and exhibits expected to be used. And then if you don't identify them, and unless they're true rebuttal witnesses or documents, then unless you've got some kind of good excuse, the arbitrator excludes them. Okay, so that gives you the protection I think you're looking for. Hey, I'm not going to be ambushed.
For both sides.
For both sides, that's right. The arbitrator also has the power to subpoena witnesses and documents. 10 days before the hearing, the director issues subpoenas requested by the parties in the names of the arbitrator. If, this contemplates that we exchange, hey, we notify each other of who we're going to try to subpoena. If we want to subpoena the city manager and you think that's not appropriate, you can ask the arbitrator to quash that subpoena. Okay? By the same token, if you want to subpoena Carlos and we don't think that's appropriate, we could ask that be quashed. And then there's a discovery provision. If you request discovery at least 4 weeks in advance of the hearing, then if we object to your requested discovery, we notify you at least 2 weeks in advance, and then we go to the arbitrator essentially, and the arbitrator decides what you get and what you don't. In the private sector, they're just called information requests. I request information. I had a real bad experience myself in a grievance arbitration many, many years ago in the private sector where I requested documents for their termination grievance, and they actually produced, on the day of the hearing, a canceled check that really made a big difference in the hearing, and I raised a stink because I'd made an information request and it hadn't been provided. And the arbitrator ultimately allowed that. I still have bad feelings about that, but I've moved on.
Well, and the thing is, if there is a document in there that nullifies or gives merit to something, I think it would behoove both parties to take care of, resolve it before going to the expense of an arbitrator,
That's right, that's
So-
right, especially when you've got a loser pay system as we do. I do want to point out that, from the union's perspective, we don't use attorneys on our side to arbitrate grievances. We use laypersons. I mean, they're trained laypersons. But so there's a real desire on our side to keep the process as informal as possible. We don't want to get tripped up on procedural rules. And this does force us to marshal our evidence potentially a little bit more quickly than we might otherwise. But we're willing to make this, move towards your position to give you the comfort level you need that you're not going to be ambushed. At the same time, the arbitrator ultimately is going to decide these disputes,
Okay.
including our procedural disputes.
Okay.
So, okay. And that's kind of it on the changes we've made to that procedure. I think, the grievance procedure as a procedure, by and large, has worked fairly well. You've had some problems with discovery. We've met those. You may feel like we filed too many grievances. We may feel like we don't file enough, but that's not the procedure. That's just, do we have too many or too few grievances? So we ask you to look at that. Then let's go to Article 25. And this one is where I really do feel we're really close, if not there, because yours backed mine to a large extent, and I've made, I think, almost all the changes that you requested. Okay, but let's go through it. Section 2 I've relabeled as disciplinary actions. You didn't like apparently my carve out of the motion, so I've just added the motions back into the mix. On fire chief's authority, you had added that he could suspend them or discipline them not only for violation of civil service rules but also fire department rules, city rules, stuff like that. I would point out that one of the civil service rules is violation of a fire department rule or regulation or standard operating procedure. So by limiting civil service rules, you know, you're not precluded from charging with violation of fire department rules. You just need to cite that civil service rule. Okay. Allowable suspensions. We were in agreement here that agreed suspensions up to 30 days. I'm sorry, unagreed suspensions up to 30 days. Agreed 31 to 90. I added your language. If you've got an agreed suspension, nobody has the power to review it. But I added a clause. However, an arbitrator can decide whether the terms of the agreement have been met. And just to give you an example, you know, sometimes I've seen these so-called last chance agreements. You know, I'm willing to suspend you for 60 days, but part of the terms of that is you won't appeal the 60-day, and if you have another identical infraction, then you're out of here with no appeal. Last chance agreement. And then 6 months later, the chief says, okay, you violated that term, so I'm firing you. And you don't get to appeal. And the firefighter says, but chief, I didn't do the bad thing you said I did. The firefighter will get a chance to prove whether or not that condition that prevents the further appeal has been met. Okay? You know, I'm trying to think of an example. If you have one more AWOL, you know, well, chief, I wasn't AWOL. You know, I had to rush my wife to the emergency room, and I don't feel like that's an AWOL. Okay, well, he could litigate that. He just could, but once that condition precedent is set, the agreement's enforced as written, and you can't appeal.
So you're not essentially appealing the agreement, you're appealing whether that condition precedent actually happened.
Exactly.
Okay.
Okay? And that's all that last little phrase is intended to create that little right. Because I actually had a case where it was an issue about whether or not we got to argue whether the condition precedent was met. And the arbitrator ultimately sided with us on that, but rather than leave it to, well, let's just make clear what the rules are now. The only thing that I had in my proposal that your proposal didn't really address is this item 3B at the bottom. It's about the investigation techniques. You know, that 3A says that you don't have to do anything in Chapter 614, and so as long as you meet whatever the investigation procedures are.
What page is that? Oh, right here on page 1?
Yeah, page 1 at the
3B.
bottom. That I highlighted it in yellow to make sure that you knew that I realized your proposal didn't really have anything about this. And I'm just asking you to consider this. There are two things here that during the term of the agreement, you use your current investigatory policies. They seem to be working for you. And then if a firefighter is interviewed and wants a union rep, that they could, as part of the investigation, they can have it. I want to point out that, you know, if the firefighter requests a union rep and you don't want them to have one, then you could choose not to conduct the interview. So, you know, okay. Then the rest of it, until we get down to, I'm looking at subsection 3F towards the bottom of page 2. I basically changed our language to kind of conform to your language. So I think what you see, the changes here you see are just accepting your changes to what we had given you. Okay. Section 4A, that addition comes from your proposal again. Determined by the arbitration procedure provided in this agreement rather than by the civil. That language is from your proposal. I've added the motion back in rather than keep it out separate. Selection of the arbitrator to hear appeal. You had put this, you had expanded our 5-day to 10 days, and so I agreed to that change. I had put in my original proposal that when we're picking an arbitrator, the city will make the first strike. You came back and said we'll alternate, but as I pointed out, you know, each firefighter. So I just said, well, we'll decide by a coin flip. Each case, we'll flip a coin to see who has to make the first strike. Okay, because it's not really, the union's not really a party to disciplinary appeals. I mean, we're often heavily involved, obviously,
Right.
But it's the firefighters.
It's individual firefighters.
Yeah. Okay. Hearing date was not, okay, hearing transcript, I had said if only one party that uses the hearing transcript, the arbitrator doesn't get a copy, you said, well, you know, we had this come up. Arbitrator last time decided they would get a copy, and what are we going to do? So that's what I put in there. Arbitrator will decide whether or not that arbitrator will get a copy. Pre-hearing procedures. I changed. I'm thinking that I originally said 2 days before the hearing you exchange witnesses' names, and you expanded that to 2 weeks, and I did a compromise of 1 week. Just let me know if you think that's accurate. But if you know a week in advance who our witnesses are, you know, and vice versa,
Yeah.
that's a problem. Parties are responsible for the cost of their own witnesses, but contemplate a continuation of the current practice, which is the department releases people as necessary to testify
Is that,
without cost to the union.
is that what it's, what, if they're on duty right now and a witness is subpoenaed by either party, they're allowed time off to come attend?
I think sometimes they even, you know, how the crew kind of moves with a person.
Okay.
You know, like if you random drug test a firefighter, you don't relieve them from duty sometimes. The crew goes down to
whole
the
crew
testing
goes.
lab with them while they get tested.
In case they get called.
Same kind of thing here. Okay. Arbitrator has the power to subpoena witness. The subpoena request by the Director of Human Resources at least 1 week prior to the hearing date. You know, again, this contemplates that, I don't think it's spelled out as clearly, and we may want to do something about that. But obviously, if you request a subpoena that we think is inappropriate, or vice versa, we can go to the arbitrator to get that quashed. Even though the Director of Human Resources is the quote-unquote issuer, the arbitrator decides who gets subpoenaed and who
Yeah,
doesn't.
you know, and that did come up, and when I was reading through these, it did come up because if it came up with, what if you want to subpoena a witness who's no longer an employee, and or we have control of the Director of Human Resources, she's our employee, but here, one of the concerns that I've thought about that I hadn't thought about before was, what if the arbitrator says, okay, union request, this expert witness from San Antonio, and then the burden now is put on the city's human resource director to somehow act as a process server and issue a subpoena out there. So we may want I'll come up with a proposal to kind of address that kind of concern. Do you know what I'm talking about?
Yeah, but I think that the director's obligation is to issue the subpoena here in Corpus.
Okay.
And then it is, whichever party requested the subpoena, it's their duty to get that subpoena served.
Okay, so I think we probably just need to clarify that
Yeah.
and spell that out.
And, that raises the whole issue of the enforceability
Right.
of subpoenas issued by arbitrators. And, they don't really have the same legal authority to punish by contempt that a judge would, obviously. They can hold it against one part or the other. I mean, if we subpoenaed the city manager, the arbitrator thought we were right, and you refused to make the city manager appear, I don't think the arbitrator really can put the city manager in jail. He might hold it against the city, who
Right.
obviously has more control. And by the same token, if you subpoena Carlos and he doesn't show up, although he will, he loves to talk. The arbitrator might hold that against us, but he doesn't have the authority to put Carlos in jail. I'll start using Johnny as an example. Because
Yeah, we'll probably need to think that through a little bit more.
Okay.
Because I think we're both on the same page with what,
and if you
about
look at
what a subpoena is supposed to mean and how it's supposed to help us
Right.
get to a resolution.
subpoena, we don't really need subpoenas, hopefully, for a person who's in control of one part or the other. Normally, we would say, we want the city manager there, and the arbitrator says, yeah, I want him there too. You would provide him, we wouldn't have to go through the whole subpoena rigmarole. And the same with us. If they
Right.
say, want my union president there, or a grievance committee chair there, they're going to show up. We got control of it.
Okay.
Item number 6, this again I think is in response to your request. 1 week prior to the hearing, exchange documents. They're going to be used as exhibits. That way nobody gets surprised. You don't have to worry about an MOU popping up that we did a document swap. Okay. Arbitrator's authority, I just added the motions because, as you can see, I've eliminated section 5. The motions are not a separate bird anymore. They're just part of it. Now, judicial appeals, I want you to,
Before we move on to demotion, so it becomes a part of the general process as well?
right, you'll
Okay.
see the demotions has been added several places up in
Okay.
up in this long section about disciplinary investigations and procedures and appeals of disciplinary. You know, section 4 says appeals of disciplinary, suspension, and discharge. That should be demotions.
Which is this section 4?
Yeah. In subsection A, it uses demotion, but I didn't put it in the title, so I've just added it to the title. And I'll send you
Oh,
the
okay.
corrected exhibit in a minute, okay? But I just added it. I just overlooked it in the title. And that's why it's been eliminated in 5, because it's captured in section 4. Now, judicial appeals, I acceded to the city's position here. I'm not sure this is what you really want. You know, you did not give the city the right to appeal a disciplinary decision. And the statute says that cities and firefighters can appeal.
Yeah, that was an oversight.
I thought it probably was, but I limited it from ours visibly on the page to make sure that you saw that you
Okay.
had done that. But I put in the standard that you want, which is Civil Service Commission standard. But if we're both sides are going to appeal, I think we want to think about whether we want to do the hearing examiner standard or the Civil Service Commission standard.
Okay.
The hearing examiner standard is more strict, and that's a two-edged sword. You know, you've got fewer rights when you appeal, but the other side has fewer rights when they appeal too. And so I just think we need to have a conversation and decide which standard makes better sense for both of us.
Okay. And we'll fix that. The oversight was not to eliminate the appellate rights of either.
No, we
so-
accepted that. We
okay.
accepted it.
Okay.
No, I'm kidding. And then agreed modification of the contractual time periods. I added the sentence you requested in your proposal. Neither party can be compelled to waive a deadline. Okay?
Okay.
We can do it by mutual agreement. We can't be compelled. Okay? So literally, I modified my proposal almost exclusively to add things or make changes that y'all had requested in your proposal. And the only thing that I think that I left out, I know, but I know that y'all will go through it carefully.
Okay. We would go through it.
And so why don't, if you want to, you can take a caucus, go through it. We'll keep working on our stuff, and if you want to come back then and ask more questions, because I know it's hard to try and read the document and hear my explanation at the same time.
Okay. Yeah, and I need to do a comparison. I like the actual pieces of paper, so it's hard for me to work on the computer sometimes.
Okay, and I'm going to
So-
send you this new proposal, but the only change I made was to add the word demotion
Demotions.
to section 4.
Okay. And before we caucus, I just wanted to touch base with you on some information you had requested. Let me pull it up here. On the last session, and an email, and during the session on email by February 25th, and the session on February 26th, you had talked about questions about certain city contributions to certain groups. I have emailed you a letter dated today, March 11th, and then the highlighted portions are the additional information you asked for, which was Medicare contribution to the police pension, Social Security contribution for each police officer, and city contributions to TMRS for non-public safety employees.
Yeah,
And
and we got it.
Okay, and if anything was left out, just send me an email. That way I have the outlined request and I can forward it and get that information
Okay.
as we go along.
Okay.
Okay?
And the other thing that I would like to ask in terms of an information request, and I'm looking at your proposal earlier today,
Yes.
and if you look at page I'm looking at page 23. 24, bottom of 23 and top of 24. This information about the cumulative net fund balance, you've given us the balance as of September 30th, 2014. But if you have a current balance, because I mean that's like 7 or 8 months old.
Okay.
If you have a current balance and can give us that, there are two different figures there. That'll kind of give us an opportunity to kind of see if the trend line is continuing or if there's some change in it or what.
Okay, I'll see if that information is available and provided to you. Remember that we discussed, you had asked that information at one of the sessions and Steve was able to get it to you. And so we didn't give you a document, but we talked about it and these were the numbers based on the last actuarial study that we had. But we will look to see if we have the actual
Updated,
current,
okay.
like as to date fund balance and on the numbers that are here and we'll provide those to you if we have that.
Okay, also, you know, we know that you've eliminated a lot of stuff from there that you say is in the plan document. Is the plan document, I mean, that's not too long, is it? Just about 10 or 12 pages?
You know, I couldn't tell you, Craig, but we can definitely obtain a copy so that we both have it and so that we have that in front of us. It's definitely is relevant to what we were talking about.
Right,
So,
right. Okay.
Okay, so I'll get the current, see if we have information on the current fund balances and get the plan document.
And don't forget to look at Articles 1 and 3, which are the preamble and the recognition.
Okay.
I think, you know, it's been a while since we TA'd anything. It'd be nice to, even if it's just the preamble,
Right.
you know, to TA.
Okay.
So, okay.
Well, we'll go back in caucus and work on those, look at those 4 proposals, counter proposals that we're talking about, and see if we can come back. Let's see, it's 2:26. Let's see. Let's give us an hour to sit through that and work through it, and I'll give you an update in your caucus room as to where we're at.
Okay. Very good. Thank you.
All right. Thank you. Okay, are you ready? Okay, during the caucus, we were able to obtain the plan document for the health of city care, excuse me, the city care fire health insurance plan, and it's a little bit more than 10 pages, that actually I think over 100.
Yeah.
So, and it came, I hope it came through, and if it didn't, I can send it once I hook up to the my big network. But I just wanted you to have that and make sure. I also copied Carlos and Johnny on it
Okay.
so that they had that healthcare plan document. When we're sitting back, we went back to the caucus room and we were looking through see what we could TA and see, you know, on the disciplinary appeals and the grievance procedure. We started identifying some issues that we really need to sit down and analyze a little bit more, and so we started to do that. Excuse me. But in the interest of time and trying to move forward on some TAs today, we've decided that the disciplinary appeals and the grievance appeals are going to take a little bit more analysis, and we'll have counter proposals prepared for the next session on that. But what we did do is we did go through the proposals that are out there to see and identify which ones we could possibly TA on today.
Okay.
One of them that you had asked was to look at the preamble. And we looked at the last union's preamble, which I believe was on 2/26/15 at about 1 p.m. I think was the last one.
Yes.
And looking upon that, and once we actually see it in writing with all the red lines accepted, once we review it, at this point, from what I saw, we can TA that
Okay.
preamble.
Okay.
The other thing I was looking at was another tentative agreement is the meals at $8. I know it was a portion of a big proposal, but I think if we can tackle, you know, little things at a time, if you would, and that way we can kind of narrow down the issues. It looked like the union proposal, the last union proposal 14, and I can get the date on that. Have it pulled up. I think that was also on 2/26.
Yeah. I know what you're talking about.
It was a 2/26, and it was Article 14, section 3 of your 226 UA 14. You came to the meals at $8 and you rearranged the language a little bit, and it basically says the same thing, and it would, as far as the procedure, it would maintain the status quo, but it moves that number to $8.
Right.
And if that's what is reflected and we review, we prepared in the TA and that's what it is, and we can TA that as well. Okay, so we've got the preamble, the meals at $8. The other two items that are also found on your UA 14, in which we actually presented on page 9 of our initial proposals today, are the sections with regard to relief and reassignment from fire prevention. That's section 4 and 5 of your UA 14, and it was found on page 9 of our initial proposal. It looks like they're almost identical.
Yeah, reassignment from prevention, you said?
Fire prevention.
And that's sections,
It's sections 4 and 5 from your UA 14 of 226-15 at 1 p.m. And it's also found on page 9 of our initial proposals from today, 3/11/15. And it looks like those are almost identical, and I think that we can TA on those as well.
okay.
The other one that we could identify that we could possibly TA is what we identified as a conflict with civil service statute found on page 46 of our initial proposal today, 3/11.
I'm sorry, give that to me again.
Conflict with civil service statute proposal. It was kind of standalone, but we need to find where to put that in the contract once we finally put it all together. My understanding is we're going to try and organize it in a comprehensive and understandable way at the end. But it was found on our city initial proposal from today, 3/11/15 on page 46. And I think that's something that we could possibly TA. It just basically says that when the collective bargaining agreement is in conflict with the civil service statute, that the collective bargaining agreement governs.
Yeah.
The other one I would like for y'all to look at is a mileage reimbursement. That was also found on your UA 14 of 226-15 1 p.m. and that's section 2.
Article which one?
14.
Section 2?
Yeah, section 2, and that was the last one of 226-15. I wanted to talk just a little bit about this because we had talked about this one at length at the last negotiation session in 2014. The way that you have it proposed refers to old language in the contract, and the old language refers to something called a city's compensation ordinance. In 2014, we kind of looked at that because we didn't know what that meant. The city does have a compensation ordinance for its general employees, but it doesn't mention anything about mileage reimbursement or how mileage allowances are set. That's actually set by, if not one, possibly two financial policies from what I recall.
Okay.
So that was the reason that we had changed the language to what our proposal is, and that's on page 10 of our, and it's found in our 311. Found on page 10 of today's initial proposals.
Page 10?
Yeah. And so what we have done was basically take out a city's compensation ordinance because that really doesn't apply here, and it doesn't, it's not relevant to the mileage allowance. And what we're trying to do with this language is make it the same and consistent across the board as it is for the entire city.
Right.
So, and I think if I recall correctly, and one of the things that we can gather for you is that policy, what I recall was that we mirrored or tried to mirror the language that's found in that financial policy. So that's one thing, I'm gonna see if I can get that for you so that you have that information. Let me write that down so I can get it. Sometimes I can't read my notes.
Okay. So basically you're saying our two proposals are the same in substance. Look at it, and if I agree, maybe we can TA on that.
Yeah. Because the way it's written has language that just doesn't make sense, like the city's compensation ordinance, it doesn't even apply to this particular issue.
Okay.
And we did have a lot of conversation with regard to this. I think we even talked about and showed the policies in the 2014 negotiations, and I'll try to get that again. There's some others that we could possibly TA, but I think when I was looking at them, there may be a couple of other issues or questions that we may ask. But so I identified, let's see, 1, 2, 3, 4, 5 that we can TA, and then the sixth one being that mileage that we could possibly TA if you look at it with the information that
Okay.
you need to refer to. Other than that, we do have to do a little bit more analysis on the grievance and the disciplinary, and we do plan on having more counter proposals to prepare the next meeting, especially because we have the kind of a working week. Even though it doesn't count towards the
Right.
bargaining period, we do plan to utilize it to
What
move
about the
forward this
recognition
process.
clause? I mean, that just seems so innocuous to me.
Oh, you know,
It's Article 3, it just says, "The city recognizes the association as the exclusive bargaining agent for a bargaining unit consisting of all firefighters. The bargaining unit does not include the fire chief, civilian employees, or cadets." I mean, that's pretty much what you've already done, or else we wouldn't be here today
Right.
representing the...
I think I had brought up the issue that we were looking at. We wanted to see with that, what I recall, and I apologize because I was trying to identify these things,
Yeah,
and I
that's
really
okay.
did just forget to look at it. But as I recall, on the recognition, we wanted to see, and it may change as we go through and we start TAing stuff, we wanted to see what the contract was going to look like, because there's a question on, on some contracts, deputy and assistant chiefs may not be included depending on what's covered by the contract. Even though I know the statute says, right now as it is, I think it mirrors the statute, and so we just wanted to look a little bit.
Right, and it does mirror the statute, and I
Right.
don't think that we have authority to change a statutorily designated bargaining unit.
Right.
That's not to say that you can't negotiate special provision for your highly placed, like say
Right.
assistant chiefs. Assistant chiefs won't be paid according to the wage scale you negotiate, but according to the city's executive policy or whatever.
Right.
And we can certainly do that, but I don't think we can exclude them from the bargaining unit. This came up actually in Oklahoma, of all places, and where it actually went to court. Could they, by contract, vary a statutory bargaining unit? In Oklahoma said no, and while I'm not arguing that we're bound by Oklahoma
No,
law.
I
I'm just saying
understand.
that I think the sort of the same analysis
But
applies.
You're identifying the exact issue that we need to do further analysis and research on, basically.
Right.
See if it's even something that is possible. So
Okay.
that's one of we have more analysis we need to look at, and that we're not ready to TA it or identify it as something
Okay,
to TA
that's
today.
fine, that's fine.
So, and in terms of, that and and then if we're able to do that, what the context of the entire contract looks like, then that would, it's relevant and a factor in looking at it.
I'm smiling because I'm remembering an old George Carlin line. What is it? The best thing you can say about your state is it's okay.
Okay, well, that's all that we have for today, because we definitely have a lot of homework to do.
Okay.
And if during the time, I know that you may be out of pocket, I'm not sure, but if there's any information that you need during this next week, just email it, and we can start gathering it and hopefully have it before the next bargaining session. And we'll try to keep moving forward.
Okay, very
Okay.
good. So our next bargaining session will be on March the 25th, which is a Wednesday.
Yes.
And both of those days are full bargaining days.
Yes,
Start at
sir.
9:30 and go till whenever.
March 25th
And March
and March
26th.
26th, yes. Those are full days.
Okay.
I did confirm the 3rd. I haven't confirmed those last 3 dates of 15, 16, and 17, but I will do that tomorrow.
Okay,
Okay?
very good. Y'all enjoy the spring break, and we'll see you on the other side of it.
Okay, we'll be
Good.
working.